Assalamualaikum and good day everyone. My name is Farah Nadia binti Mano. So today I will be presenting my infographic, which the title given is Child Witness Testimony in Malaysia, the Impact of Child Witness Amendment Act 2024. So imagine a child becoming the only witness to an incident of abuse. Under the previous law, even the child was telling the truth, the court often required additional evidence to support the child's testimony. So this creates difficulties because offences involving children frequently occur in private with no other witnesses present. This is one of the reasons why Malaysia introduced important reforms through the Child Witness Amendment Act 2024. First, let us look at why the reform was needed. Previously, child witnesses often faced intimidating court procedures and limited protection measures. The assessment of competency could also create uncertainty, while unsworn evidence generally required mandatory corroboration. As a result, some genuine cases were difficult to prove. The reforms introduced several important changes. Before the amendments, Evidence Act 1950 played a major role in regulating child testimony. A child was generally defined as a person below 16 years old, and corroboration was often mandatorily required for unsworn evidence. After the amendments, a child is generally recognized as a person under 18 years old. The law now adopts a presumption of competency, meaning that children are presumed capable of giving evidence unless the court decides otherwise. In addition, corroboration is no longer mandatory, and courts may assess the credibility of a child testimony on its own merits. The reforms also strengthen child-friendly procedures under the Evidence of Child Witness Act 2007, the children may give evidence through lifelink testimony, video recordings, screening arrangement, and assistance of intermediaries. These measures help reduce trauma and make the court process less intimidating. The legal effect of these reforms is significant. Under the old position, child testimony often required corroboration, which increased the possibility that offenders could escape liability due to lack of supporting evidence. Under the new position, the court focused on the credibility of the child's evidence, and a conviction may be based on that testimony even without corroboration. This improved access to justice for child victims and witnesses. The importance of these reforms can also be seen in the case of Muhammad Adib Sufyan bin Azman against public prosecutor, and the other case is public prosecutor and Chan Wai Heng. Both of these cases illustrates the development of law regarding the child witness testimony, competency, and corroboration. However, some challenges remain. Relying solely on child testimony may raise concerns about wrongful convictions, and children may be vulnerable to suggestion or coaching. Therefore, judges must be equipped with necessary skills to access child evidence carefully. To address this concern, continuous training for judges and prosecutors should be provided, and the use of intermediaries should be expanded, and clearer guidelines for evaluating child testimony should be developed. In conclusion, the Child Witnesses Amendment Act 2024 represents an important step toward a more child-centered justice in Malaysia by presuming competency, removing the mandatory corroboration requirement, and introducing the child-friendly procedures. The reforms better protect child witnesses while ensuring that justice remains fair and effective. Thank you.